Is for hearing and order 41 Rule 11, item 5, second appeal 567 of 2016.
This is plaintiff's second appeal also. Plaintiff instituted eviction title suit number 888.
ये इनका माइक्रोफोन ऑन करो। इतना आवाज क्यों है? रोज तो नहीं होता।
This is plaintiff's second appeal also. Plaintiff instituted title suit number 888 lordship.
Just a minute. You are the landlord?
Yes, I am landlord. First, plaintiff instituted eviction title suit number 888 lordship for eviction of plot number 11, particular khata number 1/6 and holding number 160A, 167B. The learned trial court decree the suit in our favor, lordship, saying that the defendant claimed that he is not concerned with 167 and 167B of the suit land, lordship. He is claiming only on the basis of holding number 470. So the learned trial court, lordship, observed, lordship, may I permit to read of the, although the first appellate court in para number 16 of the appellate court observed this finding, lordship, I may permit to read of the judgment, lordship.
You just read the case of respective parties from the trial.
So before coming to that, lordship, this against this title suit, lordship, defendant preferred title appeal, lordship, and title appeal was allowed and the judgment passed by the eviction title suit number was set aside and directed the first appellate court to frame issues with regard to personal necessity and for there is a relationship of landlord or tenant or not. So the first hand, lordship, I will probably read out that is observed by the learned court below, lordship. For the simple reason that defendant Akshay Kumar himself has stated that he has the first राउंड में जो हम टाइटल सूट फाइल किए थे एविक्शन सूट हम सिर्फ किए थे 160 होल्डिंग नंबर 167A 167B के लिए डिफेंडेंट बोलते हैं कि 167
होल्डिंग नंबर 167
एंड 167B
167A
167A 167B
167B ओके
डिफेंडेंट अपीयर किए बोलते हैं कि हमको 166A और 167B से कोई कंसर्न नहीं है मेरा सिर्फ टाइटल है 417 के लिए होल्डिंग नंबर 417 से एसोसिएट रिलेटेड है इसलिए ट्रायल कोर्ट ने मेरे फेवर में डिग्री ऑर्डर पास हुआ मेरे फेवर
डिफेंडेंट इज इन पोजीशन ऑफ व्हिच प्रॉपर्टी
ही इज क्लेमिंग होल्डिंग नंबर 417 so the first trial court lordship degree in our suit lordship thereafter they defendant preferred appeal lordship. Appeal.
What is the trial court judgment initial?
Trial court judgment dated. Trial court judgment dated 28/3/2000. 28 March 2000.
Initial trial court judgment.
Initial
88 का सूट.
88 का सूट है 28/3/2000 को डिग्री हुआ हमारे फेवर में. उसके अगेंस्ट में लोग टाइटल अपील डिफेंडेंट फाइल प्रीफर किए 4/2000 बिफोर द डिस्ट्रिक्ट जज कोडरमा. 17/1/2005 को सेट असाइड हो गया जजमेंट और लर्नेड ट्रायल कोर्ट को डायरेक्शन हुआ मैटर रिमांडेड टू द लर्नेड ट्रायल कोर्ट लॉर्डशिप टू डिसाइड एडजुडिकेट द इशू नंबर 1, 3, 4, 5 and 6 for fresh and deep finding regarding partial eviction. 1, 3, 4, 5 and 6 इसी पर सिर्फ एडजुडिकेट करने का डायरेक्शन हुआ.
These issues were earlier framed by the trial court.
Yes, Doctor.
But the trial court did not decide these issues.
No, not decided because defendant said lordship.
1, 3, 4, 5 and 6 all are relating to partial eviction.
No, as per the partial eviction and there is a relationship of landlord tenant or no, both issues were there, lordship. So the first
1-3. Issue number 2 became final.
the first appellate court directed lordship decide issue number 1, 3, 4, 5 and 6 only. Decide the. Now I will permit to read out the trial court judgment. The first trial court judgment. Para 3 laws. The trial court judgment.
Page number.
Page, running page number 10 laws. Eviction title suit number 888 laws.
Let us see the issues print.
Yes. That is page number 5, internal page 5, page number running page 14 laws. Paragraph 7 laws. On the basis of both the parties, the court has recast following issues. Is the suit maintainable in its present form? Is the suit barred by the law of limitation, application waiver, and estoppel, or any provisions of law? Is the suit is properly valued? Has the plaintiff got right title, cause of action for the suit?
That's what we have seen. So what do you want to show from here?
In this suit, lordship, plaintiff sent legal notice, lordship, to the defendant, lordship, on 15/7/1987 for claiming arrear of the dues, lordship. Another notice was served to the defendant, lordship, on 4.
Where is the appellate court judgment?
Yes, appellate court judgment.
So this is the judgment after remand.
After remand.
And after remand also he has recast it. You say that as per the remand order 1, 3, 4, 5 and 6 was also only
Yes,
to be decided.
remand
But he has recasted all the issues.
12 issues.
Maybe that they are all interrelated.
Yes, all of them are interrelated.
He can break up the issues. Isn't
Yes,
it?
yes.
There is no legal bar.
Yes, but so far as the defendant is claiming that he is not concerned with 167A, 160B lordship, he is only concerned with 470 lordship. So again, initiation of the trial lordship is bad in the eye of law.
So that order of remand was bad.
Yes, but plaintiff did not challenge the remand or lordship. That is,
So we can't do anything.
I cannot say lordship.
Then
Kindly see appellate court judgment lordship, page number para 20.
and the earlier judgment is also not annexed with this. You have not annexed it.
Look, first appellate court observe lordship at para 16, para 16 lordship, para 16 page 15 of the appellate court judgment we can see.
Why did the court dismiss the suit?
Court dismissed the suit lordship because we have served the legal notice lordship, and defendant Akshay Kumar also acknowledged that he received the notice lordship, and he failed to deposit the rent lordship for the month of September and October lordship at 1987 lordship. There was a delay of, there was a 2 months.
Then it should have been declared.
Yes,
This suit was dismissed.
yes,
And
because
you are the landlord.
yes, I am not landlord lordship.
Why was it dismissed?
Dismissed lordship only on the ground that lordship that defendant challenged the counterfoil of the receiving lordship.
That was disbelieved.
That was disbelieved lordship, and this matter was sent before the expert lordship, and expert said that document is not genuine lordship.
So,
Only on that ground lordship, my suit was dismissed lordship.
correct.
Since the
And that was introduced by way of amendment.
yes that was bring by way of amendment.
By way of amendment after remand.
Yes, after remand lordship. Since the defendant is only claiming on the basis of oral permission of the ex-landlord lordship, and they are claiming that they are the owner of the property, Lordship, on the basis of only Sada Hukmnama and Jamindari Rasid, Lordship. They have not produced any
Did
Jamindari.
not.
Yes,
You see, you
that
claim,
is true. That title cannot be. That title can be looked, Lordship, but that.
you claim that you have issued rent receipts,
Yes, Lordship.
isn't it?
Yes,
Which you could not prove. Which you could not prove. So where is now there is a serious dispute with regard to the title of the property. And even prima facie, your rent receipts you could not prove. Then under such circumstances, the suit was dismissed.
The learned type would exhibit 7 and 7 by 1 is Lordship. Rent receipt and signature would depend, Lordship. That is a document which the learned court ought to be decided, Lordship.
We will not reappreciate those evidences here. There is no scope to that.
Because there is a misinterpretation of document, Lordship.
No, that is not missing.
And it is said a lot of Lordship that any interpretation of the document, Lordship, is itself a substantial question of law, Lordship. Because
See, but there has to be something clinching about it. It was sent for examination by handwriting expert. The handwriting expert was also examined, and he has deposed against you. Then what kind of perversity is this? On account of if a document is wrongly interpreted, certainly it falls for consideration. But here is a case where you have not been able to prove the rent receipt that you were claiming. Then
both the learned court fully believe, Lordship, that plaintiff failed to correlate the exhibit plot number 167 and 167B is related to the suit land, Lordship. Although we have exhibit 5 series, Lordship, municipality receipt, Lordship, which says, Lordship, that 167A and 167B, Lordship, issued in favor of the plaintiff, Lordship. So this document, exhibit 5, has not been considered by landlord.
you see, the point is that you have to establish landlord-tenant relationship. Correct? So he is in possession of the property, and you said that rent receipts were issued, and you were not able to prove the rent receipt. Is there any other evidence of landlord-tenant relationship between the two? Is there any agreement?
No.
Nothing. Then they are claiming their independent title. You are also claiming your title. Both of you are claiming title, and there is no proof of landlord that a tenancy was created.
This tenancy was created only on the basis of the rent receipt, Lordship.
That's right.
Yes.
That has been disbelieved by the courts by citing reasons.
And that has not been challenged.
Then under such circumstances, what substantial question of law arises for consideration? Vicky? Essay number 567 of 2016.
May I say one thing also? Earlier एक eviction title suit 1974 इनिशिएट हुआ था. वो मेरे वेंडर के द्वारा हुआ था अगेंस्ट भुवनेश्वर प्रसाद अगेंस्ट द मुनी लॉ डिफेंडेंट. उसमें लैंडलॉर्ड टेनेंट रिलेशनशिप के बारे में उसको eviction suit हम लोग फाइल. My vendor initiated, but the judgment has not been filed.
So, if your vendor had initiated a eviction suit against them and some judgment was passed, who will exhibit that judgment?
The judgment has not, the exhibit that has judgment has not been proved, Lordship. Only the case number has been filed, Lordship, as an exhibited document.
So, you have not.
But judgment has not been.
Judgment has not been. what the learned counsel is claiming on behalf of the appellant. This second appeal has been filed against judgment dated 21/7/2016, passed by Principal Judge Kodarma in Eviction Title number 1 of 2006, whereby the appeal has been dismissed. The trial court judgment is dated 31/1/2006, passed by Learned Municip Kodarma in Eviction Title Suit number 8 of 1988, which was dismissed. Consequently, the appellant, claiming to be the landlord and also the plaintiff of the case, is in second appeal. The learned counsel for the appellant has submitted that the suit was earlier decided and the appellate court remanded the matter to decide almost all the issues and also a suit for partial eviction. The issues which are to be decided were redecided was issue number 1, 3, 4, 5, 6 and partial eviction. He has submitted that the two counterfoils of rent receipts, exhibits 7 and 7/1, 7/A, have not been properly appreciated by the learned courts, and therefore a substantial question of law is fit to be framed with regard to the interpretation of exhibit 7 and 7/A. The learned counsel has submitted that in case of wrong appreciation of documents on record, a substantial question of law can be framed and can be a subject matter of second appeal. He has also submitted that the counterfoils of the rent receipts are material documents which were placed on record, which could by themselves have been sufficient to prove the relationship of landlord and tenant.
And defendant has stated that he is not claiming holding number 167A and 167B also.
कहाँ से बोल रहे हैं?
ये ट्रैक में जजमेंट में आया हुआ है।
कौन से ट्रैक?
ये फर्स्ट कोर्ट में उनका गवाही भी पैरा 50, 55, 56 में अच्छा हुआ। He is only associated with plot number 470 lots. अपडेट कोड इसको ऑब्जर्व भी किया पैरा 16 of the update code. Learned court will find that the plaintiff's claim title over holding number 167A, 167B and defendant Akshay Kumar has stated in his testimony that he has no claim over said holding, and as such the learned court below granted decree of eviction to the plaintiffs, directing the defendant to vacate the suit premises.
Para 16 of
Para 16 the update code, first update. Page 15 notes. Running page 40 notes.
And where is the order of remand?
Order of remand details. 17/1/2005 also.
दीजिए दोनों दीजिए
Yes.
the when it comes to further appellant has also submitted that initially the eviction title suit number 8 of 88 was decided by the order by judgment dated 28 of March 2000 and the learned trial court had taken a view that the defendant Akshay Kumar stated that he had no claim over the holding number 167A and 167B, which was the suit property, and solely on this ground, the suit was decreed. He submits that the matter was taken up in appeal by Akshay Kumar and others, and the matter was remanded for taking fresh decision, being issue number 1, 3, 4, 5 and 6 and partial eviction. The learned counsel has submitted that when Akshay Kumar, who was examined as DW16, had stated at one point of time that he had no concern with plot number 167, holding number 167A and 167B. There was no question of dismissing the eviction suit, right? In the second round. After hearing the counsel for the appellant and upon going through the records, including the Judgment dated 28th of March 2000 passed in eviction title suit number 8 of 88. This court finds that the relationship of landlord and tenant was denied by the defendants. And altogether 9 issues were framed, which are as under. The learned trial court
main issue also number 5.
the learned trial court decreed the suit for the simple reason that Akshay Kumar had stated that he had no claim over holding number 167A and 167B. Although the defendants alleged that the holding number of his house was 417. The trial court observed that the plaintiff was claiming title over house bearing holding number 167A and 167B, and the defendant admitted no claim over the same holding and decreed the suit in favor of the plaintiff. The defendants took the matter in appeal and the appellate court recorded that the trial court had recorded the finding in a shortcut method only on the question of title and which was suggested by defendant number 16, and that he had no concern with the land of the suit premises. The learned trial court was of the view that the court should have decided the issue regarding relationship of landlord and tenant. Which was not clearly decided. And was also of the view that the the issue of personal necessity was also required to be decided. The matter was remitted back to the trial court for deciding the issues. Issue number 1, 3, 4, 5 and 6 and partial eviction. And to give a fresh finding in accordance with law and the evidence as available on record after hearing the arguments of both the persons. Upon remand, the learned trial court recasted the evidences, the issues in paragraph 7 as follows. And the records of the case reveal that the order of remand का date लिखी है 17/1/2005.
2005.
The records of the case also reveal that the plaintiff were asserting that they were landlord of the suit premises on the basis of counterfoils of 2 rent receipts, Exhibit 7 and 7 by A. And the same were introduced by way of amendment, which was allowed by the High Court in Civil Division number 34 of 1991 within bracket R. This court finds that upon remand, the learned trial court considered the issue number 5 with regard to the relationship of landlord and tenant. The learned trial court recorded that it was the case of the plaintiff that vendor of the plaintiff had inducted defendant's father, late Munilal, as tenant for monthly rent of ₹25. And during the period 1974-75, Munilal did not pay rent for the tenanted premises. And eviction title suit number 90 of 74 was filed, and later on it was compromised between them. It was the further case of the plaintiff that plaintiff had purchased the suit premises along with other properties and served a notice upon the defendant's father and his vendor, also informed the defendant about transfer of the property, but in spite of information, the defendant did not pay rent nor vacated the suit premises. The learned trial court recorded that in this context, the plaintiff had not brought any evidence or document relating to filing of eviction suit and its disposal upon compromise to substantiate the real dispute of relationship of landlord and tenant. The learned court further considered that it was the further case of the plaintiff that the defendants approached the plaintiff number 1 on 28/8/1987 with a request to allow them to remain in the house as tenant, and thereupon rent was settled at ₹100 per month, and defendants cleared all the dues, and accordingly rent receipt was granted on 28/8/87 for the due from March 1987 to July 1987, And in this context, the plaintiff had filed a rent receipt said to bear the signature of defendant number 3, which was exhibited as exhibit 7 and 7 by 8. And the learned court recorded that these were the only documents in support of the alleged relationship of landlord and tenant. The trial court further discussed that the defendants had denied the signature upon the counterfoil of rent receipt exhibit 7 by 7 and 7 by A, and the matter was sent for handwriting expert for opinion. Exhibit 2 was the report of the expert, and exhibit P series were the photocopies of exhibit 7 and 7 by A, and exhibit L series were the specimen signature of defendant number 3 obtained in presence of the signature. The learned court recorded that the handwriting expert has been examined as DW7, and as per the report also, the handwriting expert made it clear that exhibit 7 and 7 by 8 did not tally with the specimen signature DW17. This DW17 was also fully cross-examined. The learned trial court, after considering the materials on record, including the report of the handwriting expert and other materials, including the oral evidences of the independent witnesses, came to a conclusion that there was no relationship of landlord and tenant between the parties. And ultimately, the suit was dismissed. The appellate court also framed the following issues for consideration. Para 11 of the appellate court judgment. The appellate court also discussed the materials on record and recorded its finding in paragraph in paragraph 20 onwards. The finding in paragraph 21 and 22 is recorded as under. This court finds that the learned trial court ultimately, the learned appellate court ultimately recorded that further recorded in paragraph 26 of the trial court of the appellate court judgment, and has considered the claim of the defendant that he was claiming holding number 415, and also the claim of the plaintiff that they were claiming holding number 167A and 167B. and recorded that no document or paper was produced by the plaintiff to indicate that the holding numbers of the suit house were 167A and 167B. Paragraph 26 of the appellate court judgment. Is quoted as under. This court finds that the learned appellate court has also considered the materials on record and has given concurrent findings with regard to the relationship of landlord and tenant, and held the same against the plaintiffs. Both the learned courts have appreciated the rent receipts exhibit 7 and 7/8 and have clearly recorded that, and also the report of handwriting expert, and the findings have been recorded against the appellants. This court finds that there are concurrent findings recorded by both the courts, and there is no scope for reappreciation of evidence in as much as no perversity as such has been pointed out by the learned counsel for the appellant in the matter of appreciation of evidence. Accordingly, there is no merit in this statement which is hereby dismissed. I'll just keep this for
Yes, yes.
some time. ये इनको वापस करना है.
From supplementary list orders we defend attempt 2. First appeal filing number 10285 of 2024.
There are several defects. They pray for 4 weeks.
FA filing number FA 10285 of 2024. The counsel for the appellant prays for and is granted time till 28th of March to remove the surviving defects of the Eviction. If the defects are removed within time, pose this case on 3rd of April. That
Item 3. First appeal filing number 10639 of 2024.
Lordship, there is one defect, Your Lordship. They are asking for connected case details. There is no connected case.
what connected case detail?
No, I'm not being able to understand, Your Lordship. Because the impugned order is, the details of the impugned court judgment is given properly. The appeal was once filed before the lower court, Your Lordship, but due to pecuniary jurisdiction, we had to withdraw it. But that detail is also given in the memo.
You have to place that order. Isn't it? As per appeal value, this will lie
Before this honorable court, Your Lordship.
ये जरा स्टैम्प पेपर को दिलाई. आप उन्हीं से समझ लीजिए. I am calling you. We will let you know and then we will hear. Because unless the defects are cleared,
Your Lordship, this is only defects.
let him come.
Yes.
You come at around 12 o'clock, 12 बजे तक आ जाइएगा टाइम से, otherwise you will be detained over there.
For admission, item 5, item 4, Contempt Civil 113 of 2024.
The order has not been complied.
We are in process of the compliance mode. Today I have filed, the debit is ready in which Your Lordship may kindly see Annexure A to the petition. For remaining steps, the opposite party is praying for grant of 4 months more time for compliance of the order.
Interim order. What is interim order?
Final decision could be taken only after the matter placed before the cabinet.
Otherwise, the order is in his favor.
Your Lordship has directed to count the service period so as to complete the 10 years and grant of the pension.
So that 10 years is completed.
For that, matter is required to be placed before the cabinet.
They will calculate it.
Calculation will be done, your Lordship.
Have you have not done the calculation?
On the basis of your Lordship's order, calculation is there, because the
10 years completed, not completed. On the basis of the order.
On the basis of the order, it is not completed because your Lordship directed to shift the date of joining.
Yes. देखिए, contempt case civil number 1113 of 2024. A show cause has been filed on behalf of the opposite party, stating that the matter is now pending before cabinet.
It has not filed, it has been produced before your Lordship.
Affidavit नहीं हुआ,
Affidavit हो गया है, फाइल नहीं हुआ है,
ले लेंगे.
Lordship. कैबिनेट में अभी प्लेस नहीं हुआ है, they will place it before the cabinet. Before that, other procedure is also they are required to be adopted.
वो कौन करेगा? किसके पास करेगा?
Your Lordship may kindly say Annexure A, paragraph.
किसके पास पेंडिंग है ये बताइए.
Decision has been taken by the Director, Primary Education. Your Lordship may kindly see last two paragraph.
Yes.
WPS नंबर सेशन में दिनांक कितना को पारित आदेश के अनुपालन में हेतु प्रशासनिक विभाग को संलेख प्रस्ताव गठित करने एवं इस विषय पर कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग से सहमति प्राप्त करने का परामर्श दिया गया। वित्त विभाग से प्राप्त परामर्श के आलोक में वादी आशा प्रकाश को मात्र पेंशन आदि भुगतान के लिए न्यूनतम अनिवार्य सेवा 10 वर्ष किए जाने हेतु उनके वैचारिक नियुक्ति स्थिति मानकर पेंशन आदि लाभ के भुगतान का प्रस्ताव पर प्रशासनिक सुधार तथा राजभाषा
तो ये मामला किसके पास पेंडिंग है? आप बताइए ना, उन्हीं को पार्टी बनाते हैं. किसके पास पेंडिंग है? इस चिट्ठी का हम क्या करें? पिटिशनर क्या करेगा इस चिट्ठी का? Can you survive with this letter? Yes.
By this letter, a decision has been taken.
So how is the
And
petitioner
the respondent are seeking 4 months more time for compliance.
compliance मतलब पेमेंट करके?
Lordship. So that as it appears from the Annexure. Because they have not prefer any appeal
The
against the
learned
order.
counsel fits in. Content civil 1113 of 2024. An affidavit by way of show cause dated 17/2/2025 has been filed during the court proceedings, which is taken on record. The learned counsel for the opposite party has submitted that as on date, the decision has been taken in favor of the petitioner, which has been annexed as Annexure A to the show cause, but necessary approval from the Department of Personal Administrative Reforms and Rajbhasha, and thereafter by the Cabinet is required for passing appropriate order for payment of pecuniary benefit to the petitioner. The Learned Council has submitted that as per the show cause, 4 months' time would be required to do the needful. Considering the aforesaid submissions, pose this case on June 13th, 25 in the supplementary cause list. The supplementary show cause be filed by 10th of June. After remitting the admissible amount in favor of the petitioner. सारा complete कर लेंगे. If anything is required to be done at the end of the petitioner, appropriate communication be made to the petitioner by the competent authority.
For hearing under Rule 41, Rule 11 of CPC, Item 6, Second Appeal 318 of 2019.
My lord, second appeal arises out of the judgment of Contempt. The appellant, your lordship, was a defendant, and claim of the plaintiff, your lordship, is that defendant was a tenant in the suit premises under him for a monthly rent of ₹250. That's what is the claim of the plaintiff. They are claiming that, my lord, way back in 1932, the property in question was sold by one Shukar Sahib in favor of one Mahrami, Mosmak Mahrami. And after her death, her husband came into, inherited the property. And after the death of Rajbali Mian, the husband of Mahrami, my lord, his sons, they inherited it. And my lord, one of the sons in the amicable partition got this property. And he had inducted the defendant as a tenant, and rent was paid till 2005. When he stopped paying rent, then the suit was instituted. That has been decided. This is the nature of claim of the plaintiff. So far as the defendant, your lordship, is concerned, defendant claim, your lordship, that the Shukar Sahib never sold the property, and they have remained in all along in possession. And my lord, he had 4 sons, out of which one son died, Bola Shah died, and the 4 sons of Shukar Sahib, the property came in possession of my lord Lachpan Sahib, my lord, who subsequently in the year 2005, he issued a sale deed in the favor of the my lord Banasa Devi, who is the husband of the defendant. Their stand, your lordship, that there is no relationship of a landlord and tenant. This is what is the stand of the defendant.
There is a registered sale deed of 1932
There is a registered head of 13.
with respect to the same property.
With respect to the property. And
The
the deed is also of 2005.
Yes, certainly. So what? There are 2 sale deeds, registered sale deeds with respect to the same property. The previous one will certainly have its has credits.
Rightly pointed out, ma'am.
Now tell us, is there any proof regarding landlord-tenant relationship?
That what I was conveying. My lord has rightly pointed out My lord, from the whole judgment, my lord, of concurrence, appellate court as well as, my lord, the trial court, my lord will find, my lord, it has been dealt like a regular suit deciding the title. That is not the scope of the, my lord, the landlord suit under the, my lord, the VR Building Act. There are judgments to that effect. My lord. I have brought those judgments. So far as the evidence is, my lord, documentary evidence, no documentary evidence, your lordship, has been brought on record. That, my lord, though they claim, your lordship, that way back in 1932 the property was acquired, but the rent receipts, your lordship, which they have brought on record, is after, my lord, the institution of suit. Most probably receipt even, my lord, 2007. So, my lord, and one of the evidence in one of the defendant, your lordship, has admitted that me and my father and my grandfather you used to live in that property itself. So these evidence suggests one that even if there is a sale deed way back in 1932, that was never acted upon. And these persons, your lordship, including the defendant, he has remained in all along the position. The learned trial court has my lord,
So you are claiming adverse position?
no, I am saying, my lord, there is no landlord-tenant relationship. And the property, your lordship, is of my grandfather, your lordship, Mr. Sugar Saw. And his son, your lordship, Lakshman Saw, he had executed a sale deed in the favor of, my lord, my wife. This is what is the stand. So far as the landlord-tenancy, your lordship, is concerned, my stand, your lordship, is that I am not a tenant to him. Rather, property belongs to my wife. I am my lord, paying whatever rent or something like that is to my wife, not to my lord the plaintiff. This what is the stand. So far as the oral evidences are concerned, some of their evidence, your lordship, my lord will find that they have said 2,250 rupees was paid, but in the cross-examination portion, my lord, the defendant has denied that it was in my presence, paid in my presence. And one of the plaintiff, your lordship, has admitted that my father, my grandfather, and all these persons, your lordship, were in position, all along in position. So this is the case of, your lordship, not of a landlord-tenant relationship, but rather it is a case, my lord, in which the purely of a title suit. And, my lord, for no reason, my lord, the learned appellate court has said that our deed, 2005 deed, is a false deed. Your lordship may kindly see the findings.
Not forged, but it will certainly not have credence.
No, it has written that it is a false deed. There is no, it is also a registered deed. And a registered deed, my lord, under section 62 of the Registration Act, itself has a presumption of correctness. Your lordship may kindly see, my lord, the judgment passed by the appellate.
What is the date of filing the suit?
Well, filing of suit, 2005.
Date?
It is, my lord, 21st of July 2005. And the rent receipt which they are bringing on record, your lordship, is of 2007. Post even municipality receipts also. And it is an admitted position that I am in position. Not only my father,
There
my
is a
grandfather.
direction to pay the rent also.
Madam?
There is a direction to pay the rent also. Where is the discussion regarding landlord-tenant relationship by the learned trial court?
By the appellate?
By the
Yes.
trial court?
Well,
What was the issue claimed?
yeah. I'm giving. Your lordship may kindly see what the issue is there. It is at internal page, my lord, 5, running page 12.
Issue number 4 is the main issue.
This is the relationship of landlord. Yes. Para 4, for issue number 4. It is at page 20, running page 20, page 13. May I read?
Just
Finding the lordship is at page
Just-
26.
अब यहाँ से पढ़िए पेज नंबर 18 से.
Page number 18. उपरोक्त परिस्थिति में
हाँ.
उपरोक्त
उपरोक्त
परिस्थिति
वर्णित परिस्थिति.
हाँ?
उपरोक्त वर्णित इंटरनल पेज 18.
उपरोक्त वर्णित परिस्थिति में जब प्रतिवादी की स्थिति विवादित मकान परिसर में निवास करने के तथ्य के संदर्भ में स्वयं द्वारा दी गई गवाही से आशा देवी के किराएदार के रूप में स्पष्ट हो गई, जिसे यह तथ्य स्पष्ट हो रहा है कि प्रतिवादी विवादित परिसर में निवास कर रहे हैं। वर्तमान निकासन बाद में प्रतिवादी को नाची मकान परिसर से निष्कासन हेतु सर्वप्रथम आवश्यक तथ्य यह है कि वादी प्रतिवादी के बीच में मकान किराएदार का संबंध हो। वादी द्वारा विवादी के किराएदार के संबंध में कोई दस्तावेजी साक्ष्य प्रस्तुत नहीं किए। ऐसे में इस तथ्य के निर्धारण हेतु वादी द्वारा मौखिक साक्ष्यों का विश्लेषण सार्थक प्रतीत हुआ। सर्वप्रथम वादी मोजीब खान की गवाही का विश्लेषण आवश्यक है। इसमें साक्षी ने अपने गवाही में कहा है कि वर्ष 95 में 250 रुपया मासिक किराया देने की बात कही है, जिसका प्रतिवादी द्वारा मार्च 2005 से किराया दिया गया, जिसके पश्चात भाड़ा दिया जाना बंद कर दिया गया। साक्षी ने अपने गवाही में 5 जून से तक भाड़ा नहीं देने के कारण डिफॉल्टर बताया। साक्षी ने अपने गवाही में कहा है कि प्रतिवादी से नालसी परिसर खाली करने के लिए कहा गया तो उनके द्वारा ऐसा नहीं किया गया। साथ ही 750 रुपया भाड़ा अप्रैल से का दर बताया। वादी की गवाही संतुष्टि करते हुए अन्य वादी महफूज मिर्जा एवं कानून में समान रूप से वादी द्वारा निजी करते हुए कहा है कि 250 रुपये का प्रतिमाह किराया पर वादी को नालसी देने हेतु तथा प्रतिवादी को देने का बंद। प्रतिवादी के द्वारा इस कथन को खंडित करने हेतु साक्ष्य में वादी को किराएदार नहीं बताकर पत्नी का अपना मकान मालिक बताया है। संभव के सिद्धांत के आधार पर अभिलेख पर उपलब्ध साक्ष्य विश्लेषण के उपरांत प्रभावशाली प्रतीत नहीं होता। इसके विपरीत वादी का साक्ष्य प्रतिवादी के ऊपर प्रभावशाली प्रतीत होता।
उसके पहले भी आप देखिए इंटरनल पेज 17. प्रतिवादी गवाही संख्या 1. During cross examination admitted that they are the tenant.
No, he has not admitted.
साक्षी ने अपने गवाही में प्रति परीक्षण के दौरान नालसी मकान में वह आशा देवी के भाड़ेदार
Not a tenant to the plaintiff. Lakshmi kindly appreciate.
it is
He
tenant
said
to Asha Devi.
he says that her wife, his wife Asha Devi, is having a salary by the father-in-law of year 2005. He not admitted the tenancy with the plaintiff. The learned trial court what has done that he found that the patit hota hai. Not a clear finding also. In the last paragraph, Your Worship, may kindly see of this page. प्रतिवादी द्वारा लिखित दस्तावेज मूल निबंधित विक्रय संख्या ए 2005 तथा विवादित पत्र से संबंधित जिसे प्रतिवादी द्वारा दाखिल राजपुतार प्रतिवादी के पिता लक्ष्मण साहू द्वारा प्रतिवादी की आशा देवी दिनांक को बिक्री की गई, जिससे उस प्रतिवादी को भी प्रतिवादी के पूर्वज शुक्र साहू द्वारा वादी को निबंधित विलेख 2015 विलेख संख्या 2015 दिनांक 9/11/32 को बिक्री किया गया था, जो आशा देवी प्राप्त विलेख से पहले की है। अतः संभावना की प्रधानता के सिद्धांत के आधार वादी द्वारा स्वत के संबंध में दाखिल दस्तावेज जिसे वर्तमान में वादी एवं प्रतिवादी दोनों के बीच में एक संज्ञात्मक इशू के रूप में देखा जा रहा है, वादी का साक्ष्य अधिक प्रबल प्रतीत होता है. He is not deciding the title, who is having a title.
Title he will not decide, no?
The
He
question
will decide the relationship of landlord and
and so far as the tenant relationship is concerned, if I am a tenant since so long, there should have been some rent receipts, etc.
need not be.
And,
Is there
and
any law?
they have the plaintiff has itself had one of the plaintiff has said that we are in possession since my father, grandfather, and the case of the plaintiff is that I was a tenant under him. My case, my specific case is that my father and my grandfather is the owner of the property. That they are also not denying. That they are not denying.
And he sold the property in 1930.
Yes, but my
That
lord
too
may-
by a registered
my-
sale.
that my lord may kindly appreciate that the rent receipt which they have brought on record to my lord the
Exhibit
suggest-
number?
Yes,
Exhibit?
yes, my lord may kindly. Your lordship may kindly see page 5 of the trial court judgment.
Yes.
मूल निबंधित विक्रय संख्या 32 एग्जिबिट 8 मालगुजारी रसीद दिनांक 26/6/2007 गिरिडीह नगर पालिका 4/7/2000. No document prior to that. Merely by registered seat they are trying to claim it. They should have filed a title suit for a declaration of title and a recovery of possession. To what sort that they have filed an eviction suit. That is what my lord, point of law which I would like to my lord, suggest that my lord, where the regular title suit my lord, is required to be filed, my lord, such shortcut proceedings, your lordship, just to my lord, the claim and evict the persons, are such proceedings maintainable? Had there been my lord, consistent rent receipts, etc., your lordship, it could have been at least my lord, imagine that yes, but such documents on record, there is no evidence of my lord, documentary evidence of landlord-tenant relationship. And so far as the registered deed, your lordship, is concerned, there are two registered sale deed my lord, on record. Your lordship. One is of 1932. A second, your lordship, is of 2005, and there are the rent receipts also, your lordship, are in the name of both the parties. So admittedly, my lord, it is the issue of title which is involved in the case. And my lord, Rajendra Tiwari judgment, your lordship, may kindly have a look on this judgment passed by the Honorable Apex Court. That my lord, scope of title is beyond that. Para 7, your lordship, is irrelevant.
Asha Devi has been examined.
Asha Devi?
Asha Devi has been examined.
No.
The defendant claimed that he is a tenant under Asha Devi.
She is the owner. What is the contention?
No, he said that he is a tenant under Asha Devi.
He has said so. But the main stand, your lordship, is that the father-in-law,
And the scrutiny of the oral evidences of the plaintiffs
Right.
indicated that you are the tenant.
and not under him. That what is my contention. My status may be under the tenant or the Asha.
Asha Devi is your wife.
But maybe if that there is no bar in the law also that a husband cannot be a tenant under the wife. That is a separate issue, and it is equally well settled, your lordship, that it is the plaintiff who has to prove his case. He has come with a specific case that I was a tenant under him on a monthly rent of ₹250, and my lord,
You see, the learned court has considered the oral evidences also.
appellate court has not considered, not scrutinized those evidences.
But trial court has considered it.
Trial court has
Trial
considered.
court has considered all the oral evidences to come to a finding of the landlord-tenant relationship.
Yes, I agree to that.
Yes.
But the question is, your lordship, that my lord, oral evidences, your lordship,
Are excluded.
No, I am not saying so. But your lordship may kindly appreciate a person who is having in the property since 1932. My lord, no rent receipt also been brought on record that actually it was the property, the property. And my lord, so far as we are concerned, my lord, the plaintiff has himself admitted that not only me, my father, my grandfather, your lordship, is residing. Even my grandfather died, my grandmother died in the suit premises. We are residing in in that property in such a long time, not as a tenant. What is the contention? And this is a pure question of title, that whether the person can have a title on the basis of a deed of 1932, or the person who is having this in the property by virtue of a deed 2005, he can have some title. So issue of title is to be decided, and not in the my lord, eviction suit. Eviction suits are summary proceedings, and eviction suits are to be dealt like that. The only what is important is that a landlord-tenant relationship is to be my lord, established. And so far as my lord, this particular case, your lordship, is concerned, my lord, there are two contention of the plaintiff. The first, your lordship, is that there was a default in payment of rent. Second one, your lordship, was that, my lord, he required it bona fidely also. And, my lord, in cases of bona fide, my lord, requirement of bona fide, the onus lies on him, my lord, as per the section 2 of, my lord, the Bihar Building Act, that he should prove that there is a ownership also. So unless, my lord, ownership is not proved, my lord, at least, my lord, the eviction is not permissible on the ground of bona fide necessity. That requirement is not mandatory so far as the default in payment of rent is concerned. But, my lord, from the entire, my lord, the case records, my lord, will find that it is the issue of the title which is actually, my lord, involved in the matter. My lord, the plaintiff want to evict us, my lord, by filing an eviction suit, whereas, my lord, the requirement in law was to file a regular suit by, my lord, filing a declaration for title and for confirmation of possession. But, my lord, in this particular case, it was
Second appeal number 318 of 2019. Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against judgment dated 31st of July 2019, asked by learned District Judge Roman to BDT in civil appeal number 42 of 2017, whereby the appeal has been dismissed. The trial court judgment is dated 27/5/2017, passed in eviction suit number 8 of 2005 by learned Munsif BDT, whereby
लेकिन ये इशू है, ये इशू इसलिए हम कहेंगे कि है क्योंकि
आप देखिए
हटा के इस तरीके से हटाने का तो एक तरीके से ये कट शॉर्ट करके ही करा है.
whereby the order of eviction has been passed against the petitioner and against the appellant, and the appellant has been directed to deposit rent of 3 months of rupees 750 within 3 months and hand over vacant possession of the property. The learned counsel for the appellant has submitted that both the parties were claiming title over the property. The plaintiff was claiming title by virtue of registered deed of the year 1932, and the defendant was claiming title by virtue of registered deed of the year 2005, executed in favor of his wife, namely Asha. The learned counsel has submitted that the trial court has proceeded in a manner as if the title was to be decided between the parties. Rather, the core question was as to whether there was landlord-tenant relationship between the parties. In absence of that issue having been properly decided, instead of deciding the rival claim of title, the judgments passed by the learned courts cannot be sustained. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court, reported in AIR 2000 Supreme Court 136, para number? Para 7, to submit that while dealing with the question of eviction, the moot question is as to whether there is a relationship of landlord and tenant. The learned counsel has submitted that at no rent receipt has been exhibited by the plaintiff, and the defendants have been residing over the property for quite some time, and they were the owners of the property by virtue of the sale deed executed in the year 2000.
Not only slightly disputed, it is the admitted case of the party that in the Khatian also the name of Sugar Saw is there. So it is the Khatiani land.
आप भी तो सेल डीड लिए हैं ना?
My grandfather, their claim is that it is my grandfather who has sold the property in the name of one Mehrani, Mosman Mehrani, by virtue of a sale deed way back in 1932. It is not in dispute that it is not a Khatiani property.
The learned counsel has also submitted that it is not in dispute that the suit property originally belonged to one
Sukasa.
Sukar Sahu Sao.
Yes, yes.
Sukar Sao.
Yes. We have brought Khatian also.
After hearing the learned counsel appearing on behalf of the parties, this court finds that the plaintiff had filed eviction suit number 8 of 2005 on the ground that the plaintiff was the landlord and the defendant was the tenant, and primarily the allegation was default of rent. The case of the plaintiff was that defendant Subhash Sahu was inducted as monthly rent in the property at the rate of rupees 250 per month in the month of January 1995, and continued to pay rent, and defendant lastly paid rent for the month of March 2005 at the rate of rupees 250, and thereafter he defaulted and fell in arrears. The property was said to have been purchased from Super Sao by virtue of registered deed of sale dated 9/11/1952. And it was asserted that in favor of Mosammat Muhorami Khatun, and after her death, the plaintiff came in possession of the property along with others, and he got the property involved in this case by virtue of partition.
No, Morami came in position.
Morami came
Came in position. Thereafter, after her death, it is
There was partition.
It is after her death, her husband came in position, and thereafter, at the death of her husband, the sons, he had two sons. They came in position.
मोरानी खातून, ये पैरा 1 पैरा 2 से ले लेंगे, पूरा स्टोरी दिया हुआ है इसमें। हाँ, ये ट्रायल कोर्ट नहीं, एपीलेट कोर्ट। The learned counsel has submitted that the defendant claimed that this court finds that the defendant did not dispute that the land was initially recorded in the name of Super Sao, and it was their case that after the death of Super Sao, one of his sons sold the property by registered sale deed in the year 2005.
Yes.
2005.
Son name is Lakshmi Sir.
To the wife of the defendant, namely Asha Devi, and the defendant, and she acquired her title and possession over the land and house, and the defendant was running his shop in the suit premises with her permission,
of Asha.
of Asha Devi, and the defendant was neither the tenant of the plaintiff nor the plaintiff was his landlord, and he claimed that he was paying rent to Asha Devi, who was the landlord. The learned trial court considered the materials on record, and admittedly there was no documentary evidence with regard to payment of rent, but the learned trial court scrutinized the oral evidences led by the plaintiff and also considered the cross-examination and came to a conclusion that the defendant was the tenant of the plaintiff. The learned trial court also recorded that the defendant, instead of claiming to be the tenant of the plaintiff, claimed that he was the tenant of Asha Devi. The appellate court also scrutinized the oral evidence with regard to claim of tenancy and came to concurrent finding after scrutinizing the materials. The learned appellate court has scrutinized the oral evidences in paragraph 14 of the judgment. This court is of the considered view that the tenancy can certainly be proved by oral evidences and no perversity as such in the matter of scrutiny of the oral evidences as such has been pointed out by the learned counsel of hearing and court. This court is of the view that the court has considered the case of has also considered the case of respective parties who were claiming title over the property by virtue of registered sale deeds. The appellant, the plaintiff was claiming title by virtue of registered sale deed of the year 1932, and the defendant was claiming title of his wife by virtue of registered sale deed of the year 2005. This court is of the view that the learned court has scrutinized the material and has come to a definite finding that there was landlord-tenant relationship between the parties. The argument of the learned counsel for the appellant that instead of entering into the issue of landlord-tenant relationship, the learned courts have decided the title between the parties is devoid of any merits in view of the fact that the learned court, upon scrutinizing of the oral evidences on record, has come to a definite finding of landlord-tenant relationship and that the suit premises was upon a payment of rent of rupees 250 per month. This court is of the considered view that there is no scope for reappreciating the materials and coming to a different finding in absence of any perversity, and accordingly no substantial question of law arises for consideration in this appeal, which is hereby dismissed. You have seen the
Assault case item 3, first appeal file number 10639 of 2024.
क्या है इसमें प्रॉब्लम है? रिमूव हो गया? Done. All the defects removed. What बनाइए. Yes. Counsel for the appellant is present. Post this case under appropriate heading tomorrow. कल आप इसको post कर देंगे. Appropriate heading में, ठीक है? चलिए next question. आज ये ऑर्डर किए हैं, इसको आप नोट बना लीजिए. इसको appropriate heading में कल प्लेस करते हैं. एडमिशन के लिए प्लेस करते हैं. कल
I can say one second appeal 142 of 2020.
In this case, Lord, I pray for short password. Till the Contempt Mr. Sandeep Verma will argue in this case. He is on leg at court number 13 years. I only pray for short password.
Who will argue this case?
Till the Contempt Mr. Sandeep Verma, Lord.
On the last day, Mr. K.P. Ambassador was
Today,
appearing and he said that he has not brought the file.
as per my instruction, Lord. Till the Contempt Mr. Sandeep Verma, he is ready for conflict. He is on leg at court number 13, Lord. I only pray for password for 1 or 2 days, Lord.
इस तरह से नहीं होता ना. कोई भी काउंसिल आके खड़े होंगे, आज फाइल नहीं लेके आए हैं. Somebody else will
He is
say.
present here, Lord. Suppose in case of
Item 8, second appeal 98 of 2021.
Considering concurrent finding of both the courts, I was the plaintiff in the suit. The suit was originally filed for declaration of right title interest as well as confirmation of possession. The case of the plaintiff, my lords, is that the land was settled in favor of the
The suit was dismissed.
suit was dismissed and the appeal was also dismissed. Land was settled in favor of the plaintiff by way of 2 hukumnamas, both of the year 1937. One dated 12/6/1937, by which 5.10 acres of land was settled.
2637.
12/6/37.
Otherwise,
18/7/37, by which 2.60 acres was settled.
first one is second is 2.60 acres.
Yes.
First one is
5.10.
5.10. Executed by landlord.
Ex-land.
Rent receipt.
Yes, so upon vesting of the zamindari.
Exhibits.
Yes.
Not upon vesting.
No,
Rent receipt by landlord.
zamindari rent receipt is not on record.
Record of right. Any entry?
Zamindari receipts are there on this exhibit 6. Sorry. Record of right is
Is exhibit?
6 to 6G.
What are the dates? Anyways, we proceed in your own manner.
Yes. And then after wasting of the zamindari receipts, whereas the ancestor of the petitioner was recognized as a real, rent receipts were issued from 1953 to 1963-64. Meanwhile, whereas it was declared to be a forest land, but I'll come to that later. Thereafter, rent receipts were stopped being issued. So I initiated a proceeding for issuance of rent receipt, and by order passed in 1999, my rent receipts were again issued till 2005. And one more thing, whereas it was marked in the map for under forest area. So I had also initiated a proceeding for release of the land, and by a speaking order passed in 1962, which is 18/3/1962.
Land was released.
Land was released by the
Why
forest
did you
settlement.
lose the case?
Forest settlement officer, yes. Minus both the courts below have relied upon a notification issued under section 29 of the Indian Forest Act, by which the land was notified to be a protected forest land. What both the courts have failed to consider is section 29 sub clause 3 provides that all notification under section 29 of the Forest Act has to be subject to existing private rights, and this fact has not been considered. The second ground for dismissal of the case is that both the courts have held that the forest settlement officer does not have power of release of land, which is partly correct in the sense that whereas section 11 of the Indian Forest Act provides that for proposed forest, the forest settlement officer can release the land. But the question is whether he can release the land after it has been declared under the notification under section 29 is a different thing. But it cannot, but the fact remains that the section 29 subclause 3 notification is always subject to private rights, and that is something that both the courts have failed to consider.
So your private right crystallized must prior to the notification.
Yes. In notification minus they are saying is notification is dated 1953, and the land has been released in my favor in 1962.
Just a moment. 1953, what is the date of notification? You were issued rent receipt in 1953.
I was being issued, so I have been recognized as a rayat. And thereafter also in 1999 by an order, my rent receipts were again issued.
Where is the substantial question of law? We are seeking adverse possession.
No adverse question, there is no pleading.
You have made a question of law, substantial question of law. The right, title and interest has been confirmed by adverse possession.
Yes, I cannot argue that there is no pleading to that effect. And otherwise also I am claiming title on the basis of Hukunam. I cannot have contrary plea of adverse possession.
So which is your substantial?
F, point number F.
No provision for inquiry into rights of private persons.
F and H minutes. So far as 29.3 is concerned, is that question of law has not been framed properly in the
Right for Indian Forest Act.
It's been a writ petition. Your Lordship had passed a judgment that it is subject to private right. I was not able to find this. It was way back in 2021-20.
Even I remember to have passed such an order, but in a writ proceedings and in a suit are two different
Yes.
things. That order attained finality.
Yes, madam, it has not been challenged.
No such notification will be made unless the private right has been inquired into.
Yes, madam.
So the inquiry of the private right was done.
There is no pleading to that effect. And my case is that whereas the notification was issued prior to the order by which my land has been released. In the proceeding in which my land was released, it was due inquiry was conducted, evidences were laid, they were given an opportunity of being heard. They did not bring on record this notification that they have brought on record in the suit. And rightly, now they are saying that the order was passed, the forest settlement officer did not have the jurisdiction to pass the order. But rightly or wrongly, there is an order which has been passed in their presence in which they appear. That order has never been challenged. That order has been passed way back in 1962, by which my land was released.
We heard the learned counsel appealing on behalf of the appellant. The counsel for the appellant has submitted that the appellant is claiming the land by virtue of Sada Hukumnama executed by the ex-landlord as back as on 12/6/37 for an area of 5.10 acres and 18/7/1937 for an area of 2.60 acres. He submits that the Hukumnama was followed with possession and issuance of zamindari rent receipt, and after vesting, the rent receipts were issued for the period 1953 onwards till 1963-64. He has also submitted that thereafter the state stopped taking rent from the plaintiffs, and accordingly a proceeding was initiated, and by virtue of an order passed in the year 1999, the state accepted the rent till the year 2005. The learned counsel has also submitted that a notification under section 29 of Indian Forest Act 1927 was issued, which included the present property, and the issued in the year 1953. And the private property of the plaintiff was released by virtue of an order dated 18/3/1962. The learned counsel has submitted that even as per the provisions of section 29 of Indian Forest Act, the private rights are protected. He submits that the order of release dated 18/3/1962 attained finality. But in spite of the aforesaid factual background, the suit filed by the plaintiff seeking declaration of title and confirmation of possession.
Yes.
And confirmation of possession has been dismissed. The appeal has also been dismissed. Considering the aforesaid submissions, this appeal is admitted for final hearing on the following substantial question of law.
C would be more.
C. C करिए. It will be open to the parties to advance arguments for claiming additional substantial question of law once the record is received from the consent court. State is the respondent.
Yes.
You are there. The counsel for the state is present. आपका तो by name इतने लोग पार्टी हैं, and accordingly no notice be issued to respondent number 1 to 2. 3 Saket Bihari Soren, range officer, तो by name party बना हुआ है. You have to issue notice to 3 foreign parties. Let notice be issued to respondent number 3, 4 and 5 for which requisite under ordinary process be filed before this court within a period of 1 week. Let the records be called for from the concerned court. Close this case under appropriate heading on 8th of April.
Item 9, second appeal 199 of 2022.
There is concurrent finding of both the lower court against the appellant here also. In the trial court, your lordship, I am defendant your lordship.
What was the suit for?
Lordship,
What was the suit for?
lordship, as per the plaintiff your lordship, plaintiff is the Jamabandi Rayat of the Moja Punjisar your lordship, situated in the district Devghar your lordship of JB number 1 plot number 302 regarding 77 acre of the land your lordship. The recorded tenant is lordship Haitu Kumar. Thereafter, lordship Haitu Kumar is the recorded tenant, and thereafter after him your lordship Rupan Kumar your lordship. Rupan Kumar is the father of the plaintiff your lordship, and thereafter plaintiff has come your lordship. As per the plaintiff your lordship, on the request of the father of the defendant your lordship, who is the appellant before the honorable court your lordship, Rupan Kumar allowed to him to leave your lordship and cultivate the land your lordship. Requested some piece of the land being the homestead your lordship in the year 1936 your lordship.
Rent period, yeah.
Lordship. As per plaintiff your lordship, on request Rupan Kumar allowed to leave and cultivate land lordship on Batai your lordship, and used to
Batai
pay
and half.
Batai and yes your lordship.
And monthly rent also.
Monthly rent 100 rupees per month your lordship, but there is no such any document your lordship. But after the death of the Rupan Kumar your lordship, father of the plaintiff your lordship, defendant denied to pay the rent lordship, and during the altercation your lordship, that one mutation case number 356 of 7677 dated 27/6/97 1977 is under challenge your lordship before the title suit your lordship. As per the defendant case your lordship, defendant stated your lordship before the trial court your lordship that they are the distant relative of the Haitu Kumar recorded tenant your lordship, and father of the defendant also Pandit your lordship, being homestead and landless, requested this Haitu Kumar your lordship in year
Who is
1936.
Haitu Kumar?
Haitu Kumar is the grandfather of the plaintiff your lordship, recorded tenant of Jamabandi Rayat your
Haitu
lordship.
Kumar is a recorded tenant.
Yes your lordship.
No.
Yes your lordship.
Lokhan Kumar died issueless and his interest devolved upon Haitu Kumar. As per your case.
Haitu Kumar your lordship.
Haitu Kumar is not the recorded tenant.
In the last Ganja settlement, the name has been recorded Haitu Kumar your lordship, grandfather of the plaintiff your lordship.
Alright.
Yes, lordship. Father of the defendant your lordship, being homestead landless, requested Haitu Kumar your lordship in the year 1936 to provide piece of land for living and cultivate your lordship. As such, on request your lordship, 66 decimal of land has been given your lordship, which has been cultivated, and building has been constructed your lordship, which is still position your physical position in, since 1936 your lordship. And in the year 1977 your lordship, after the death of this Haitu Kumar your lordship, some dispute has been arises your lordship. Thereafter your lordship, Rupan Kumar, the father of the plaintiff, executed a amalnama your lordship in the year 1977, and on such your lordship, there is mutation case number 356 of 76 of 77 your lordship has been initiated your lordship, in which
Executed Nadavi Patra.
yes your lordship,
What is Nadavi Patra?
amalnama your lordship.
What is Amalnama?
Amalnama your lordship, there is an agreement your lordship.
No property can be transferred like this.
Yes your lordship.
Is it a registered
Me-
document?
May I? further, Your Lordship, notice has been given to Solana, Your Lordship, mutation case has been allowed, Your Lordship. Thereafter, rent receipt. But in the title suit, Your Lordship, what happened after the death of Rupan Kumar, who has participated in the mutation case proceeding, Your Lordship, and signed.
Mutation will not decide the title. Did you claim adverse possession?
Lordship, that is such, Your Lordship, that neither the trial court nor the appellate
Did
court,
you
Your
claim
Lordship.
adverse
Yes, Your
possession?
Lordship.
From where do you say this? पूरा
Lordship,
तो आपका केस पढ़ लिए, कहीं पे adverse possession का कोई जिक्र नहीं आया.
1936 का इसमें
Merely because you say that you are in possession of this property by virtue of amalnama or whatever.
Lordship,
But no plea of adverse possession.
no
Adverse possession सिर्फ ये थोड़ी होता है कि खाली इस तारीख से possession का adverse possession.
but the misinterpretation of the Bahuri Lal Jain case, Your Lordship.
What is Bahuri?
Bahuri Lal Jain, Your Lordship.
Adverse possession is specifically required to be pleaded.
Yes.
जब 4-5 ingredients होता है, ऐसे होता है adverse possession.
Yes, Your Lordship.
You are claiming title by virtue of one deed.
The Amalnama, Your Lordship, which has been executed, Your Lordship, and he was in physical possession since 1936, Your Lordship.
So what?
And Bahuri Lal Jain case has been cited, Your Lordship, at page number 18, Your Lordship. But it was misinterpreted, interpreted, Your Lordship.
कहाँ है बहुरी लाल जैन?
Page number 18, Lordship, issue number 6, Your Lordship.
अरे भाई judgment दिखाई है.
Lordship. Matter related to the adverse possession, Your Lordship. Neither the trial court nor the appellate court has framed any issue on the adverse possession, Your Lordship.
आपने तो ये नादाबी पत्रा एग्जिबिट किया?
Lordship.
एग्जिबिट नंबर?
Exhibit number D, Your Lordship.
कहाँ से बता रहे? एग्जिबिट बी.
Exhibit D, Your Lordship. Page number 26, Your Lordship. Page number 26.
of the trial court judgment.
ट्रायल कोर्ट में भी है लॉर्डशिप, अपीलाट कोर्ट में इसमें डिटेल दिया हुआ है. पेज नंबर 26 करंट. लिस्ट ऑफ डॉक्यूमेंट्स.
अमलनामा और नादाबी डीड दोनों सेम.
सेम है लॉर्डशिप.
कहाँ है जिक्र इस?
पेज 26 में लिस्ट ऑफ डॉक्यूमेंट्स में लॉर्डशिप.
Where is the discussion of this document?
The document, Your Lordship, in the trial court, Your Lordship, page number 16, Your Lordship. Second last paragraph. It has come, Your Lordship. Besides that suit, Your Lordship, plaintiff filed a title suit before the assistant settlement officer court, Your Lordship. Parallel, Your Lordship, and the order has come in his favor, which has been challenged, Your Lordship, and it has been executed, Your Lordship. But in Commissioner Court, Your Lordship, the order has been reversed, Your Lordship, and finding has given in my favor, Your Lordship, but the same has not been executed in appellate court, Your Lordship. Which is public document, Your Lordship. It has come in page number 16, Your Lordship.
खुटफानामा का क्या कहानी है 1936 में?
लॉर्डशिप 1936 में ही जो उनके फोरफादर जो थे हैतु कुमार वही एक्सक्यूट किए थे लॉर्डशिप, उसी के बेसिस पर ये म्यूटेशन हुआ था 1976
1936 में का कोई खुफानामा आपने दिया है?
लॉर्डशिप।
That is not exhibited.
Not
खुफानामा तो
exhibited,
कोई exhibited नहीं है.
लेकिन इसमें विटनेस का इसमें आया हुआ है लॉर्डशिप।
Witness से नहीं होगा ना.
हाँ, और उसमें फादर रूपन कुमार उसमें जो एक्सक्यूट किया है उनका भी स्टेटमेंट आया हुआ है, वो समझना होगा।
You were directed to be evicted by an order passed in TL case number 38 of 2008.
Yes, your lordship, which has been challenged during the pendency of the title suit, your lordship, and order has come in favor of me, your lordship, during the pendency of the appeal, your lordship. But the same has not been admitted, your lordship.
Additional evidence दिए थे.
Yes, your lordship.
Additional evidence has been rejected.
Yes, your lordship. Kindly look for a moment, your lordship. It is a matter of 15.
Additional evidence.
लॉर्डशिप टीएल केस जो उसमें आया हुआ लॉर्डशिप,
उसका नहीं पूछ रहे हैं. एडिशनल एविडेंस फाइल किए थे आप?
फाइल किया गया था लेकिन उसमें रिजेक्ट कर दिया गया।
Where is the order of rejection of additional evidence?
इसमें नहीं है लॉर्डशिप।
फिर किसमें नहीं?
नहीं, अपीलेट कोर्ट में नहीं उसमें एडमिट किए हैं।
अरे भाई एडमिट नहीं किए हैं तो उसका रिजेक्शन ऑर्डर होगा
कहीं
ना.
कुछ नहीं, इसमें नहीं कहीं कुछ लॉर्डशिप।
कहाँ से आप बोल रहे हैं? कब आप फाइल किए थे एडिशनल एविडेंस?
During the pendency of the matter in appellate court, your lordship, the order has been finalized by the commissioner court, your lordship.
Where is the plea of additional evidence? Did you file additional evidence before the appellate court?
appellate court हमारे इस order को नहीं execute किया lordship।
अरे भाई बिना एडिशनल एविडेंस के फाइल किए हुए कैसे उसको एक्सेप्ट करेंगे? दिखाइए जरा। ये क्या रिट पिटीशन है क्या?
No, lordship।
फिर एडिशनल एविडेंस तो देना पड़ता है ना।
वही फाइनल ऑर्डर है लॉर्डशिप, बस 2 पेज का ऑर्डर लॉर्डशिप। कैन यू लुक फॉर अ मोमेंट ऑन व्हिच द टीएल केस हैज बीन डिसाइडेड लॉर्डशिप। मैटर इज प्योरली ऑफ द एडवर्स पोजीशन एंड कम्स इन बबली लाल जैन केस लॉर्डशिप।
तो 21/6/22 को डिसाइड
Yes,
हुआ।
your lordship. Before just
अपील
4
कब
months
डिसाइड हुआ?
appeal decide your lordship। पच्चीस नवंबर 2022 को।
और सूट कब का है?
सूट है लॉर्डशिप 2002 का लॉर्डशिप। प्लेंटिफ 2001 में टाइटल सूट असिस्टेंट सेटलमेंट अफसर के पास में ही फाइल किए थे, अब बाद में फिर पैरेलल ये टाइटल सूट में भी चले गए।
और ये जो टाइटल सूट में डिसीजन हुआ तो इसका जिक्र आपका
इसलिए भी वो पेंडिंग था लॉर्डशिप, उसको हम चैलेंज किए।
ये तो 2022 में जब ये डिसाइड हुआ तो वहाँ पे नहीं बताया कि टाइटल सूट था क्या?
हाँ, वहाँ पर बताया गया लेकिन नहीं एडमिट किया लॉर्डशिप, वही था ना पार्टी।
नहीं ये कमिश्नर को कोर्ट में भी तो कहाँ बताया है कि टाइटल सूट डिसाइड हो गया आपके अगेंस्ट में? वहाँ भी नहीं बताया।
नहीं, उसमें तो सिर्फ टीएल केस को चैलेंज किया गया था लॉर्डशिप।
हाँ तो टाइटल सूट अब टीएल केस को चैलेंज किया गया था तो आपने वहाँ नहीं बताया कि सूट डिसाइड हो गया। अब टीएल केस को फिर आप यहाँ पे बोल रहे हैं डिसाइड करने के लिए, कैसे हो?
टीएल केस आया हुआ लॉर्डशिप टाइटल सूट में ही आया हुआ, क्योंकि एक ऑर्डर उनके फेवर में आ गया तो वो दिखा दिया, बट अनफेवर का जो चीज था वो नहीं होता है। ये इट इज अ मैटर ऑफ प्योरली एडवर्स पोजीशन योर लॉर्डशिप व्हिच हैज बीन डिसाइडेड बाय द कोर्ट।
एडवर्स पोजीशन तो आपने इसमें क्लेम ही नहीं किया है।
यस योर लॉर्डशिप,
इसमें क्लेम ही नहीं किया ना एडवर्स पोजीशन। आपको क्या लगता है ये ऑर्डर चैलेंज नहीं हुआ होगा? ये ऑर्डर फाइनल हो गया है?
फाइनल ऑर्डर है लॉर्डशिप, ये चैलेंज नहीं हुआ। सब्सटेंशियल क्वेश्चन में हम इसमें लाए हुए हैं लॉर्डशिप।
देखिए तो बार पंडित करके कोई केस फाइल हुआ है। PAL कृष्ण पंडित। कौन से सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए हैं?
Para 5, Your Lordship. Whether the Court of Appeal as well as the trial court has completely misinterpreted the order passed by the Honorable Bench of Patna High Court, White Order number 17, Bahri Lal Jain and others versus SDO and others reported as transfer, Your Lordship. It is a matter of purely adverse possession, Your Lordship.
आपको क्लेम तो करना पड़ेगा ना, आपने टाइटल सूट में एडवर्स पोजीशन कहाँ क्लेम किया है? Where is your claim of adverse possession?
एडवर्स पोजेशन का कहीं पर इशू नहीं फ्रेम किया गया लॉर्डशिप, सेम इशू वही फ्रेम कर दिया गया है लॉर्डशिप इन पेज नंबर लॉर्डशिप, काइंडली लुक फॉर ए मोमेंट, पेज नंबर 17 एंड पेज नंबर 27 योर लॉर्डशिप, एज एग्जैक्टली योर लॉर्डशिप जो ट्रायल कोर्ट का वही अपीलेट कोर्ट का भी है, पेज नंबर 17 लॉर्डशिप ट्रायल कोर्ट लॉर्डशिप। Kindly compare page number 17 and page number 27, Your Lordship.
इशू नंबर 8 का फाइंडिंग कहाँ है?
Page number 19, Your Lordship.
उसमें तो आपके पोजीशन को 1936 से रिजेक्ट कर दिया।
1936 से
Claim of your possession since 1936 on the
Yes,
basis
Your
of Kurfanama
Yes,
has been
Your
rejected.
It has decided under section 20 of the SPT Act, Your Lordship.
No, the case of the defendant is that they were in possession of the suit land since 1936 on the basis of Kurfa. But said Kurfa has not been filed by the defendants and mere assertion is not enough.
Lordship, matter has been decided on the basis of under section 25 and 42 of the SPT Act, Your Lordship. But SPT Act says that, Your Lordship, prior to the 1949, Your Lordship, if any person comes in possession of 12 years, Your Lordship, and this appellant, Your Lordship, came in possession in the year of 1936, Your Lordship.
That story has been disbelieved by the court. अब आपका contradictory order आ गया है, इसको आप additional evidence में भी नहीं लेके आए हैं, तो क्या करेंगे बताइए? ये additional evidence में तो नहीं लेके आए हैं आप इसको, आप कहाँ से बोल रहे हैं कि additional evidence का rejection होता ना?
Lordship.
कहाँ?
TL केस का इसमें जिक्र है लॉर्डशिप।
TL केस का जिक्र की बात नहीं कर रहे हैं। TL case has been, the order of TL case has been set aside in the appeal, right?
Lordship.
Did you bring it to the notice of the court by way of additional evidence?
Lordship, the same has not been admitted by the appellate court, Your Lordship.
कहाँ से बोल रहे हैं आप? कहाँ लिखे हैं आप petition में that your additional evidence has not been admitted? If your additional evidence has not been admitted and not been rejected also, then the matter has to be remanded.
Lordship, इसमें substantial question of law में हम लाए हुए हैं
The
लॉर्डशिप।
additional evidence.
Yes, Your Lordship.
बताइए कहाँ कौन सा substantial question?
Para 6 में लॉर्डशिप, whether the court of appeal has completely ignored and not accepted the order passed by the learned commissioner, संथाल को ना
अरे
डिक्लेयर।
not accepted ऐसे नहीं होता है, not accepted additional evidence के लिए petition फाइल करना पड़ता है, उसके बाद additional evidence allow होता है, कौन बताएगा आपको? Read petition है ये। Did you file your petition for additional evidence? तो एक भी एडिशनल एविडेंस का कहानी नहीं है, आप ऐसे फाइल कर देंगे तो कैसे टेकअप करेगा कोर्ट उसको? SPT agreement. आपका तो एडवांस पोजीशन का प्ली को रिजेक्ट कर दिया आप लेट हो आप फाइल किए थे एडिशनल एविडेंस के नहीं फाइल किए थे क्या आपको पता नहीं?
नहीं फाइल किया गया लॉर्डशिप, लेकिन नहीं एडमिट किया गया एज पर इंफॉर्मेशन योर लॉर्डशिप।
ऐसे नंबर 199 of 2022. The learned counsel for the appellant has submitted that an order of eviction was passed against the appellant under section 20(2) under section 42 of Santhal Pargana Tenancy Act ETL case number 38 of 2008 by the order dated 28/2/2009. But the said order was set aside by the appellate authority by the Court of Commissioner Santhal Pargana Division Dumka in RMA case number 56 of 2009-10 by judgment dated 21/6/2022, which happened during the pendency of the appeal before the learned appellate court. The learned counsel has also submitted that the said judgment was sought to be brought on record by filing additional evidence before the learned appellate court, but the same was never allowed. From the perusal of the impugned orders, the aforesaid fact is not very clear that the records be called for from the concerned court. The question of law will be framed only upon perusal of the records. Let this order be communicated to facts. Appellate court और trial court दोनों को देनी चाहिए, इसको देनी चाहिए facts. इसमें डेट 20 मार्च.
For hearing item 10, second appeal 381 of 2017.
Here this matter was being done by Mr. Sanjay Kumar Tiwari, who has become a government advocate. Today only I have received and one person's Vakalatnama is wanted. So that is to be filed, and others today are to be filed. The Deputy Commissioner is a party in the matter.
तो आपको टाइम चाहिए.
एक तो का वकालतनामा नहीं आ पाया है, बाकी लोग का तो आ
नहीं आ पाया है तो हम लोग क्या कर सकते हैं? नहीं आ पाया है तो
appellate number 6
नहीं आ पाया है तो we are not to be
नहीं
now
बाकी तो हमने मंगा लिया
तो अपील नंबर 6 का क्यों नहीं मंगाया?
वो भी
बताइए.
आ जाएगा लेफ्ट इसको
इस ग्राउंड पे तो टाइम नहीं है. आप फ्रेश वकालतनामे आपने किसकी तरफ से फाइल की?
तो सब की तरफ से एक्सेप्ट 6.
It means appeal number 6 is well aware that Mr. Sanjay Kumar Tiwari will not be conducting this case, correct?
लेकिन
If he chooses not to
आज
appear, that is his
एक्चुअल
problem.
में मिला है जस्ट पार्टी है टू लेट हम इट्स किसी दूसरे दिन रखा
तो गलत है ना. इतने सारे अपीलेंट हैं,
नहीं सब का
अपील फाइल नहीं
all
करेंगे.
persons वकालतनामा today we have received except 6 that will be also be made available.
He is the sister. He is the sister.
Yes, also. But see, on the side, outside Jharkhand.
डिसमिस कर देंगे ना उनका केस. पता है ना उनको कि उनका केस यहाँ पेंडिंग है. Now she is also aware. She is also aware
Yes, also.
that this case is pending.
But she is not well educated.
We will record that she has been contacted, but she is not interested in pursuing this case.
Person, I will inform appellant number 2 to bring her.
हम लोग यहाँ से नोटिस नहीं करेंगे.
No, I will inform.
You will be filing petition.
Next week.
The learned counsel for the appellant has submitted that fresh wakalatnama on behalf of the appellants except appellant number 6 has been filed,
Has been received.
which they undertake to file during the course of the day. The learned counsel has also submitted that they are in the process of seeking instructions from appellant number 6. At their request, post this case on Patai. Fifth March. 5th March. On 5th of March, under the heading of final disposal. Respondent comment? Nobody is appearing on behalf of the respondents. Notice complete होगा तभी hearing में.
Item 11, second appeal 376 of 2019.
In this order, Mr. Rahul Gupta and namely, he has to take Mr. Suraj Kumar to hospital. So my prayer is unelected
Rejected.
after 2 days.
आपको time नहीं देगा. Parties have requested for an early hearing of this case. Why did you make a request for early hearing? Yes? Why did you make a request for early hearing? Record है? किस ग्राउंड पे आपको टाइम चाहिए?
This case has to argued by Mr. Rahul Gupta. And
So?
वो hospital चल गई.
हॉस्पिटल क्या हो गया?
एक एडवोकेट को ये हार्ट अटैक आया था, उनको लेके पास
कौन एडवोकेट कौन
मिस्टर सूरज
सूरज कुमार कोर्ट नंबर 4 के सामने उनको आर्गू करके निकले, उसके बाद उनको हार्ट अटैक।
उन्हीं के साथ
सूरज कुमार जो मिस्टर इंद्रजीत सिंह के साथ में?
नहीं, सूरज एमएम शर्मा
नहीं, वो तो सूरज कुमार सर। आधा घंटा पहले 4 नंबर कोर्ट के बाहर गिरे, हार्ट अटैक आ गया, उनको तुरंत लेकर
अभी जो इन्फॉर्मेशन पता चला कि सर इज नो मोर।
नहीं सीपीआर दिए गए,
सीपीआर नहीं, अभी हॉस्पिटल से एक बताया है, अभी आया इन्फॉर्मेशन।
बिल्कुल हम लोग को प्रॉब्लम ये इससे भी हुआ है लॉर्ड सिंह, हम लोग जो गाड़ी पार्किंग करते हैं वो रोड पे ही लगाते हैं, उससे प्रॉब्लम निकलने लगे।
हॉस्पिटल
जो बाइक पैच है उस पे नहीं लगा, ब्लैक लिस्ट पे
पहुंचने में देरी हो गया।
आप पहुंचने में लेट।
आप लोग को ये किसी को हायर क्यों नहीं करते पार्किंग के लिए?
ऊपर बोला गया,
किसको बोला गया?
एसोसिएशन के मेंबर्स किसी को हायर कीजिए, पुलिस को क्यों वहाँ पे नहीं लगाने के लिए?
नहीं ऐसा नहीं। देखिए आई टेल यू वन थिंग, व्हाट इज हैपनिंग, बहुत सारे नए ड्राइवर्स आते हैं, नया ड्राइविंग सीखे हैं, उतना बढ़िया से पार्किंग नहीं कर सकते, ठीक है? अब कोशिश करेंगे तो धक्का लग जाएगा, तो उनको जहाँ जगह मिलता है वहाँ पार्क कर दो। आपको एक ऐसा आदमी चाहिए जो उनसे चाबी लेके ढंग से पार्क कर दे और जाते समय उनकी गाड़ी ढंग से निकाल दे। आप समझ रहे हैं? ये सारा चीज फेस किए हुए, इसीलिए आपको पता है
ये तो फिर
कि बहुत दिक्कत होता है ना, क्योंकि ऐसे पार्किंग बैक करना, पार्क करना बहुत मुश्किल काम है, इतना आसान नहीं है, बट दिस इज वेरी अनफॉर्चुनेट। करें इसको? कब कर देना?
2 दिन के बाद मेंटल स्टेटस का 2 दिन बाद थर्सडे
Yes, then I will play that it is in the first week of March, my lords.
Essay number 376 of 2019. Counsel for the appellant is present. Counsel for the respondent prays for adjournment on the ground that Mr. Rahul Gupta has left the court for some urgent work. At the joint request of the learned counsel for the parties, holds this case for final disposal on 5th of March.
Passport case item 7, second appeal 142 of 2020.
He was so young, sitting in the hall. My lord may so collect his Suraj Kumar.
Suraj
Kumar, up to 20 years practice.
फोटो दिखाएगा.
छोटे-छोटे बच्चे हैं इनको.
अरे हाँ, इसको तो अच्छा एनर्जेटिक कर दिया. अभी आर यू श्योर कि
मेरे कज़न अभी आए हुए थे आईफा में, तो वही वो लेकर गया था हॉस्पिटल. उन्होंने मेरे सामने में गिरा, तभी वही बताया कि इसने पारस हॉस्पिटल में.
हम लोग को बहुत स्ट्रेन लेना नहीं चाहिए. जो है कि मतलब लगता है
स्ट्रेन से नहीं होता है. वकील को पता ही नहीं चलता है उसके बॉडी में क्या है. स्ट्रेन का बात नहीं है. जो इतना वो एनग्रॉस रहता है अपने काम में, उसको अपने पर्सनल हेल्थ के बारे में. यू रिमेम्बर मिस्टर एमएम बैनर्जी हाउ ही एक्सपायर्ड? वी हैड नो आइडिया कि उनके साथ क्या चल रहा है. छोटा-छोटा पेन को तो ऐसे ही इग्नोर किए रखते हैं कि आज तो केस कर लेते हैं, कल जाएंगे, परसों जाएंगे, यही सब होते रहते हैं.
well prepared very little notes. This is against judgment of reversal.
किसी का बात नहीं.
Huh?
दो पेज है,
I think it mail. Sorry.
जो पहले दिए थे.
कोई भी
इसमें से ना नीचे से थोड़ा कटा हुआ.
हाँ, वही.
This is the order.
You are the defendant or the plaintiff?
defendant.
Lost in both the courts?
No. Suit filed by the plaintiff, file dismissed.
209.
ये
आपका कौन सा मैटर है?
सप्लीमेंट्री था. आपका डेली में.
second appeal 142 2020. My lord, the plaintiff filed the suit on the basis that this is admitted case that Raghunandan Prasad Bhagat, he was grandfather of the plaintiffs number 2 to 8 and grandfather-in-law of plaintiff number 1. Now, Raghunandan, the case of the plaintiff is that the suit land was allotted to in the name of Mahendra Prasad Jaiswal in a partition suit. Now, Mahendra Prasad Jaiswal died in the year 1949-50. Thereafter, it is a specific pleading. This is important. That's why I have stated. I have copy of plate also. that there was subsequent oral partition followed by memorandum of partition dated 15/1/1966, wherein the suit land was allotted to Jagtendra Prasad Jaiswal, means father of the plaintiff number 228 and husband of plaintiff. So it is their specific case that till 1966 there was jointness in their family. Now we appeared, my lord, and we filed a written statement. The defendants is claiming the suit land on the basis of one registered deed of sale dated 7/2/1950. This 19/7/1950, this property was transferred to Chhajulal and Hiralal. Hiralal was son of Chhajulal. Thereafter, my lord, Hiralal died, leaving behind 3 sons, and the suit property was allotted to father of defendant number 1, and then defendant number 1 transferred the suit property to defendant number 2.
Who is this transferee to this registered deed dated 7/2/1950?
My lord, this one, my lord, in favor of my lord, Chhajulal.
Who is Chhajulal?
Chhajulal is the grandfather of defendant number 1. Hiralal Sarma, my lord, I have written, my lord, Raghunandan Bhagat sold one so and so by registered deed 7/2/1950 in favor of Chhajulal and Hiralal. Hiralal is son of Chhajulal. Now Hiralal Sarma died, leaving behind 3 sons, and suit property was allotted to father of the defendant number 1. So in this way they are connected, the defendant number 1.
So
now the trial court has, my lord, has specifically held in internal page trial court findings, my lord, internal page 21. Separate issues were framed. One of the issues was also relating to limitation, because although sale deed 1950 was not challenged, but there was a specific issue was framed that whether this sale deed dated so and so is legal, valid, binding. Trial court का finding, my lord, kindly see internal page 21, para 12.
you see, you are the defendant.
Defendant. I am the
The
defendant.
plaintiff had filed a suit for declaration of sale deed dated 6/7/2010,
Yes.
executed by defendant number 1 in favor of
Defendant number 3.
as not binding,
Yes.
and coming under the provisions of list pendency.
Yes. Now this sale deed, by virtue of which we transferred, now my lord kindly comes to issues. My lord, I have stated the case of the parties. Paragraph 4, my lord, kindly see. Internal page 7, issues as there, my lord.
Yes.
So issue number 3 was relating to limitation, and issue number 8. This issue was also framed, about which my lord has asked in whose favor it has been executed. Now, if this document is to be declared valid, then only defendant can claim. Now, kindly come to trial court finding regarding issue number, my lord, relating to limitation, paragraph 14. This is on page number 24. Paragraph 13 है, my lord. The discussion is on paragraph.
Yes.
Internal page 23.
Yes.
The The relevant I am reading, and I will read entire but relevant. From the paragraph 13 के just ऊपर वाला. From the aforesaid discussion and settled principle of law, I find that firstly the suit of the plaintiff is hopelessly time barred. Secondly, it is also barred by the principle of waiver. Thus, issue number 3 is also decided against the plaintiff. So, limitation issue was decided against plaintiff. Now, my lord, kindly comes to the appellate court. There is no finding. This finding has not been reversed. Now, points for determination, my lord, will have a look to this is on paragraph 16 of the appellate court's internal page 11. So only these 3 points were framed by the learned first appellate court while exercising order 41 rule 31 relating to title of the plaintiff, second in relation to cell deed dated 7 to 1950, and third relating to 34 of the specific relief. Now, no points for determination, no findings, limitation point, and this cell deed point was different. Separate issues were framed by the trial court, but there is no finding on the point of limitation. Trial court has held that this deed is void document. I will also address upon that point also. But there is no finding at all on the point of limitation.
Barred by limitation with respect to
Suit.
what?
Respect to filing of suit, suit is barred by limitation.
The suit was for declaration of the sale deed of 2010 as well.
10 as not binding, not legal,
Yes.
and in that suit, the plaintiff specifically stated that this sale deed, 1950 sale deed, is void document, illegal document. A specific issue was framed. That's why I added.
But it was not under challenge. Forget it. It was not under challenge. 1950 deed was not a, it
Not
was a
under-
registered document.
It was that is my document on the basis
That's
of
right, maybe
yes.
your document.
Yes, yes. So that
But
is
that was not under challenge.
not. That was not.
What is the plea of lis pendens?
A doctrine of pendens, but they have to prove. My lord may
No,
kindly.
what was pending? What was the suit
No-
that was pending that it is said
Nothing,
to
my
be
lord.
lis
My lord,
pendens?
one partition suit was filed in which the suit property was allotted to this one, my lord Mahendra Prasad Jaiswal.
No, what? Why this the plea of lis pendens has been?
My lord, I also fail to understand. There is no evidence why they have prayed. That's why the learned trial court has also held that there is no specific evidence regarding that. Only reference that there was one suit, my lord, in the of partition suit. If my lord will have a look to the pleading, my lord, kindly comes to the my lord trial courts. If my lord will comes to second paragraph, internal page 2 of the trial court. May I read?
You see, para number 30 of the appellate court judgment. What
Yes.
is it?
Yes, void. Is declared void. That doctrine of also lis pendens also applied to those drafts. Now, my lord, kindly see list of exhibit. No document in relation to any pendency suit is there. My lord, kindly comes to my lord, paragraph 8 of the First appellate court, learned first appellate court judgment, my lord. This exhibit 3 is the final decree relating to which I have stated, my lord. Now, shall the challenging year of the 2010. Now, other shall they challenging in the plaint of the suit relating to 1950 shall deed, exhibit which is exhibit B, my lord. So there was no lispendence because there was no evidence. Lispendence है तो कोई ना कोई तो डिक्री होगा, कोई जजमेंट होगा. They have not brought on the record any documentary evidence.
What did the appellate court do?
Appellate, now one more thing relating to limitation I have stated, but trial court का एक और finding है. In fact, this deed of 1950 which they have challenged in the body of the writ, they sought no relief, no, not required. Suppose my lord just assume that this is wide ab initio, they were not party to that said deed, so they have not challenged. Very well. Now, but that is the specific case of the plaintiff. I will show from the record that this Raghunandan Prasad Bhagat sold the suit land along with other lands on 7 to 1950 by virtue of registered deed of 7 to 1950. This is admitted case of the parties that Raghunandan Prasad Bhagat was the grandfather of the plaintiffs. Now this is admitted case in their plaint that up to 1966, there was some jointness. So any document, any registered deed executed by Karta, Malak grandfather at that time, cannot be declared to be void. Cannot be. Trial court taken note of this fact, my lord, that since property was allotted in partition suit in favor of Mahendra Prasad Jaiswal. Now Mahendra Prasad Jaiswal died before his father did. So trial court has taken note of some decision of Honorable Apex Court also that in such circumstances, since father was the Karta, he was the natural guardian. Now the kindly see, but the trial court, the first appellate court has differed with this view. Has stated no, mother will be the class 1 heir, so this deed is void ab initio. So this deed is void ab initio. Although this is not disputed that this deed, 1950 deed, executed by grandfather of the plaintiff, so that cannot be declared as void document. At least there can be voidable, and if it is voidable, then relief was sought by the plaintiff. Now kindly comes to the trial court's finding, my lord. Better it would be. My lord, paragraph 11 of the trial court judgment. This is on page number 17.
Page number?
17 of the trial court's judgment.
Yes.
Yeah. I have considered the rival submission made by and on behalf of the parties and have also perused their evidence adduced in this case. First of all, I am of the view that issues 7 and 8 are the main issues to the suit, and onus lies upon the plaintiff to prove that they have right, title, interest and possession over the suit land. The plaintiffs have claimed their right, title, interest over the suit land with pleading and evidence that in the partition suit number 18 of 1934, one Mahendra Prasad Bhagat was impleaded as minor party to the suit, and the mother of the minor, namely so and so, Thanda Devi, was appointed as guardian for the suit. The suit was brought by one Babu Nilkant Prasad Bhagat against his father Raghunandan Prasad Bhagat, three minor brothers Sambhu Prasad Bhagat, Mahendra Prasad Bhagat, and Narendra Prasad Bhagat, and his mother Dhanda Devi for partition of all joint family property, movable and immovable. This suit was finally decreed on compromise. It was recorded in para 7 of the compromise that defendant number 1, Raghunandan Prasad, would not get any share in the property because he had caused loss to the state by bordering loan on the state. He would get his maintenance from his wife, Thanda Devi. It is further recorded that suit land would be in the share of minor Mahendra Prasad Bhagat. Upon such pleading and evidence, it has been argued on behalf of the plaintiff that the said Raghunandan Prasad Bhagat had no right to execute sale deed with respect to the suit land. It has also been argued that the said sale deed were never given effect to and remained only a paper transaction. It has been argued on behalf of the defendant that there is no evidence on record for showing and establishing the fact that the said minor Mahendra Prasad Bhagat was being looked after and all affairs of the minor was being managed by his mother so and so. Further, she was not appointed as guardian for her minor son Mahendra Prasad Bhagat under the prevailing law, and she was not a natural guardian under the Hindu law. After death of Mahendra Prasad Bhagat, his father Raghunandan Prasad Bhagat became the owner of his share given in the alleged partition suit of the year 1934. In case of Jijabhai Vithalbhai Gajre, reported in 1971 SCR Volume 2-1, the Supreme Court held that we are inclined to agree with the view of the High Court that in the particular circumstance of this case, the mother can be considered to be natural guardian of her minor daughter. It is needless to state that even before the passing of Hindu Minority and Guardianship Act, the mother is the natural guardian after the father. The above act came into force on 25th August 1956 and उसका डेथ हो गया 1949-50 में स्पेसिफिक केस है प्लेंटिफ अंडर सेक्शन 6 ऑफ नेचुरल गार्डियन ऑफ हिंदू माइनर इन रिस्पेक्ट ऑफ माइनर्स पर्सन as well as the minor's property are the father and after him the mother. The position in Hindu law before this enactment was also the same. That is why we have stated that normally when the father is alive, he is natural guardian and it is only after him that the mother becomes the natural guardian. But on the facts found above, the mother was rightly treated by the High Court as natural guardian. It has also been found by the High Court and all the revenue tribunal that mother was protecting the appellant and looking after her interest and was managing the suit land by leasing to them to tenant. There is no evidence to establish that transaction of lease in any way very an imprudent one or not in the interest of the minor appellant. It has also been found that the lease in the
See, this issue was itself wrongly framed.
yes,
There was no occasion to frame this issue with regard to legality and validity of this sale deed.
Yes.
It was not under challenge.
no, because plaintiff has not sought relief, but I have claimed they have in the body of the plaint.
Maybe, but unless it is directly under challenge.
Because they have plaintiff in pleading stated that I am claiming on the basis of this one, and they are claiming on the basis of this deed. This deed is void document. We have stated no, this document is not void.
You see, this is not a
Yes,
void ab
I
initio
understand.
document.
Yes. That's why. Yes.
So unless that document was,
So
they
this was
did
not.
not challenge it because
Yes.
of the reason they knew that it is barred by limitation.
Yes. It's,
They knew that it is barred by limitation, इसलिए उसको challenge नहीं
Yes,
किया, उसको
yes.
बोला void document.
I could not say that. So and my lord will see.
So the trial court says that it is barred by limitation. Anyways, issue number 8 is barred by limitation, it is irrelevant.
Irrelevant limitation.
Yes.
And this one regarding that who will be this is admitted case that father at death was occurred in the year 1949-50. Father was the natural guardian as per the law. Now what first appellate court has said, my lord, I have shown the judgment of the learned apex court also referred by the trial court. Now, my lord, kindly see the findings of the first appellate court.
They have reversed the dictate.
Yes, they have reversed. So this is the difficulty. Only 4 lines, my lord, will see, my lord, will find the illegality. Internal page 18. Internal page 18 of the first appellate courts, my lord. Paragraph 27 के पहले 4 लाइन. Admittedly, the mother of Mahendra Prasad Bhagat, who died issueless, became the owner of the property left by her son, and Raghunandan Prasad Bhagat, the father, who claims to be Karta of the family, had no authority to deal with the property left by Mahendra Prasad Bhagat.
आपका क्लियर हो गया है इसमें? रिकॉर्ड आ गया है?
नहीं, रिकॉर्ड तो नहीं है. I have here filed one caveat, that is caveat number 189 of 22 on behalf of one of the defendants here, that is the Nikhil Kumar Jaiswal.
बाकी
बाकी को नोटिस जाएगा. और को छोड़ के सब कुछ.
और बताइए आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ कहाँ है? अच्छा, आप लोग हाथ से लिख के देते हैं, टाइप क्यों नहीं करते हैं?
नहीं, मैं कल रात मतलब टाइम नहीं था, स्टेनो बाबू का भी तबीयत खराब था, तो हम सोचे कि इजी हो जाए, इसलिए.
आपको टाइप करने नहीं आता है?
नहीं.
तो आखिरी कर दिया.
नहीं, आँख के प्रॉब्लम के कारण नहीं टाइप करते, स्ट्रेन पड़ता है, आँख के प्रॉब्लम से. सो
You are the defendant.
Yes.
You are claiming on the basis of this deed of 7 to 1950.
हाँ, वो क्लेम.
Can we say that? हाँ बोलिए.
एक अनफॉर्चुनेट इंसिडेंट
हाँ, मैं भी सुने.
सूरज का कोर्ट में ही कोर्ट नंबर 4 में आर्गुमेंट करके निकला, उसके बाद से हार्ट अटैक.
मुझे समझ नहीं आ रहा है. He's तो इतना अच्छा लड़का था, इतना बड़ा.
क्रिकेट हम लोग के साथ जितने बार भी हम लोग का टीम गया, हर बार गया हुआ. क्रिकेट खेलता था, स्पोर्ट्समैन था, अच्छा प्लेयर.
तो यहाँ भी एक आध केस तो किया ही है, वो 3 केस किया है. आप लोग का जो पार्किंग है उसमें भी गड़बड़ है ना?
हाँ, वही पता चला कि वही अभी गेट के सामने भी थोड़ा सा ले जाने में प्रॉब्लम.
नहीं, देखिए आप लोग को लगता है कि एक ऐसा आदमी रखना चाहिए जिसको ड्राइविंग भी आता हो,
गाड़ी
ड्राइवर टाइप का, क्योंकि पार्किंग सबको करने नहीं आता ना ठीक से. कोई भी खास तौर पे, मतलब वैसे तो लेडीज के लिए नहीं हम ऐसा स्पेसिफिकली बोलेंगे, लेकिन हो सकता है उनको ढंग से पार्किंग ना करना आता हो, तो जहाँ जगह मिली वहाँ पार्क कर दिया. तो जैसे कि सब जगह पार्किंग लॉट में होता है, रांची में तो नहीं होता, लेकिन बाकी सब जगह होता है, वहाँ ड्राइवर रहता है, वो पार्क कर देता है गाड़ी और निकाल भी.
अभी तो कुछ दिन पहले का ही है, यही एक लड़के को कन्वर्जन हुआ. हम अपने गाड़ी में लेके गए थे, इतना वो अनइजी फील कर रहा था कि अगर हम लोग टाइमली नहीं जाते तो पता नहीं क्या होता नहीं होता. वो एकदम से वो सांस वास ले नहीं पा रहा था. और यहाँ हम लोग वहाँ पे था, एक एम्बुलेंस भी हम लोग के पास में मिल गया था बाद में. अभी यहाँ एम्बुलेंस भी एट प्रेजेंट हम लोग को नहीं मिल पाया. और जो आर्य गुप्ता साहब का जिस समय हार्ट अटैक हुआ था चैम्बर में, जो हम लोग लेके गए थे, उस समय भी कंडीशन इस तरह से जाने
और
के
अब इतना दूर हो गया ना शहर
बहुत-
से, यहाँ पे
शहर से
बिना
दूर हो
एम्बुलेंस
गया,
के बहुत
बहुत दिक्कत है, तो होना ही चाहिए।
ये बस इनका मैटर सुन भी रहे थे इतना देर से ना, लेकिन माइंड थोड़ा
नहीं था,
डाइवर्टेड
हम
ही
लोग को
था।
भी लगा कि एटलीस्ट आपको
सोच
लगा
रहे
पता
थे।
है कि नहीं, हमको
नहीं, हमको पता तो चला, अब कोई बताए हमको, इनको इसी पॉइंट पे एडमिट कर,
जी।
ठीक है। और बस सेकंड हाफ में फिर नहीं बैठना, आप लोग सब जा ही रहे
हम लोग जाएंगे।
Second appeal number 142 of 2020, heard the counsel for the applicant. This appeal will be heard on the following substantial question of law. इसको कोट करते हैं. Respondent number 4 has already entered appearance through caveat.
Caveat number 189 of 22.
Caveat number 189.
22.
22. So no notice need be issued so far as respondent number 4 is concerned. Let notice be issued to respondent number 1, 2, 3, 5 to 9, for which requisites for service of notice under ordinary process be filed within a period of 1 week. That the records be called for from the concerned court, pose this case under appropriate heading on 30th April. इसको ले लीजिए. हम इसमें एक चीज और फ्रेम करना चाह रहे थे. Was there any occasion to enter into the legality of the sale deed?
Yes.
दोनों कोर्ट उसमें एंटर किया है.
दोनों कोर्ट बहुत
लिखिए तो एक और इसमें एक चीज और लिखिएगा. Whether the courts were legally justified to enter into the legality and validity of the sale deed dated 7 to 1950, registered sale deed dated 7 to 1950, which was not specifically challenged by the plaintiff in the suit, in the prayer of the suit. Second half we will not see. Then आप लोग सब जाइए तो देखिए भाई इसका काम भी.
ठीक बोले कि हम लोग को पता नहीं चलता है कि हमको करना क्या.
नहीं पता चलता है.
That is the main reason.
एडवोकेट्स या कोई भी प्रोफेशनल्स कभी अपने प्रोफेशन से इतने बिजी हो जाते हैं कि उनको नहीं पता चलता कि क्या है. यहाँ पे तो हेल्थ कैंप वगैरह के लिए आप लोग बोलेंगे तो हम लोग लगाएंगे. आप लोग रिक्वेस्ट करेंगे तो हम लोग लगाएंगे. हम लोग रेगुलर लगाना. यहाँ पे अभी तो आई कैंप एक, लेकिन हाई कोर्ट के लिए स्टाफ के लिए लगा.
सेकेंड इशू जो वो है वो बहुत इम्पोर्टेंट है कि कोई ऐसा इम्प्लाई हो, जैसे जितने भी होटल्स में लोग जाते हैं तो
सब पार्क करने के लिए रहता है.
वो ले लेता है चाबी और कर देता है. आज आते समय एक लेडी एडवोकेट नाम नहीं बताएंगे, पीछे से मेरी गाड़ी में ठोक दी.
अरे भाई
तो
ये
प्रॉब्लम
बहुत नेचुरल बात है. इसमें क्या
हड़बड़ी में है.
हड़बड़ी में भी है. दूसरा बात उतना बढ़िया ड्राइविंग भी नहीं. धीरे धीरे ना आदमी सीखता है ड्राइव करना. सोचता है कि यहीं पार्क कर देते हैं, धक्का मारने से ज्यादा अच्छा यहीं
ड्राइव
पार्क
नहीं कर पाते मेन रोड नहीं कर पाते.
And everybody can't afford a driver all the time.
नहीं कर पाते, दिक्कत है.
Yes, Mr. Sani, are you saying something? अभी एक अनफॉर्चुनेट इंसिडेंट हो गया सेकंड हाफ में.
4 नंबर से बहस करके निकले हम सीधे गोइंग टू कोर्ट नंबर 1. हम जानते नहीं थे, मैसेज देखे तो बड़ा था. रिजल्ट विद मी आल्सो.
ये ना मतलब कोर्ट का स्ट्रेस का बात नहीं है. ये अपने प्रति नेग्लिजेंस का बात. छोटा छोटा सिग्नल्स को हम लोग इग्नोर किए.
कुछ सुनने से हो सकता है सर्वाइव शायद.
नहीं, अब पहुंचाने में भी देर हो गया ना काफी. मेरे ख्याल से गाड़ी निकालने में भी बहुत देर. एसोसिएशन कुछ करे आप लोग सब. कोई मतलब हर चीज के लिए हाई कोर्ट के ऊपर क्यों डिपेंड है? You should do these things for yourself.